should be
Actually, we're doing for it.
We both know temperature rise. She majored in like showing an entity.
Sorry about that.
Yeah, she's gonna attend this summit for youth environmental leadership that she organized. I've never bullied young people, 16, 12 grade, 5 hours leadership in environmental issues. They give them
So good evening, everybody. We're going to get started now. So I'm Terry Nagel with Sustainable San Mateo County, and I'm really thrilled to have you all here tonight. And we're very happy to have these speakers who are going to give us the highlights about their story with a lawsuit that made headlines internationally in their lawsuit against the state of Montana. We also are very grateful to the Burlingame Parks and Rec Department for sharing this room with us, which is a zero net energy building, by the way. And we also will have plenty of time for Q&A after the presentation, so you can wait until then. So I want to introduce first just a few VIPs here tonight. We have from Burlingame, the Vice Mayor, Donna Colson. Can you stand up? And also Burlingame Council Member Emily Beach. And from the Hillsborough City Council, Leslie Ragsdale. And I also want to invite all the staff, the board members, and the advisory council members who are here from Sustainable San Mateo County to please stand up, take a bow. And we are very pleased to have many excellent organizations co-sponsoring this program tonight, so I just want to take a moment to recognize them. So when I call your group's name, if you could stand and just wave hello. First, Actera. Who's here from Actera? Great. And Citizens Climate Lobby. The Citizens Environmental Council. Here we go. Yeah. And Peninsula Clean Energy. I know I saw famous. Drive Alliance. And I don't know if anybody's here from 350 Silicon Valley. Oh, you are here. Great. Okay, so we all know that it takes a village, right? But now we know it's going to take more than one village. It's going to take lots of villages, lots of states, lots of countries in order to transition away from the fossil fuels and unsustainable policies. So we're proud to be working closely with all of these groups because we can do so much more together. So I want to just say a couple things about Sustainable San Mateo County. We were founded in 1992. We are focused on a sustainable future for everyone in San Mateo County. And we were doing this before people even knew what sustainability was. I think it's pretty well respected now. We believe in the 3 E's of sustainability. That is that the environment, the economy, and social equity all have to be in balance in order to have a sustainable world. We have 4 key programs. And first we want to invite you to our annual awards celebration each spring. And that is an opportunity to pay tribute to local sustainability heroes and also green buildings. We hope you will also make a point of coming to our 27th annual Indicators Report launch, which will be on October 26th. It's a breakfast, and we'll be revealing our findings and recommendations on the welfare, the well-being of children, youth, and families in San Mateo County, which is kind of a different approach for us this year. Our main focus, though, is on helping local cities become more sustainable. And we do that by tracking their progress with our sustainability dashboard, which you can see in the lower left, and then sharing those results with the city leaders and introducing them to proven solutions from our Sustainability Ideas Bank, which now has, I think, close to 100 solutions in it. We found that copying someone else's progress is a much faster way to make progress than to have everybody reinvent the wheel. Tonight, I'd like to introduce our speakers. They are, first of all, Phil Gregory, and he is a trial attorney based in Redwood City who serves as a lead counsel for the Montana case that you'll hear more about tonight, as well as another case, even bigger at the federal level, Juliana versus United States. These two cases and quite a few others are among the ones that the not-for-profit organization, Our Children's Trust, is pursuing on behalf of young people to secure their legal rights to a safe climate. Phil has been working with Our Children's Trust on a pro bono basis since 2010, and he also has done a lot of other climate environmental work. He's brought cases involving groundwater contamination, preserving old growth redwoods, and saving coho salmon. Also with us tonight are 2 of the 16 young plaintiffs in the Montana case who were victorious. And it is really an honor to have these inspiring young leaders with us tonight. We're very happy to see you. So Sariel Sandoval is from Ronan, Montana, where she lives on the Flathead Indian Reservation. She attends Cal Berkeley. She was 17 when this case was filed, and she's now 20 years old. She and her family have a deep connection to the natural world. And during her testimony, the trial judge found that her testimony was compelling because of the distress that the climate change had caused her. For Indigenous youth, like Sariel, extreme weather harms their ability to participate in cultural practices and access traditional food sources. We also have with us tonight Kian Tanner, who lives on his family's property in Big Fork, Montana. He was just 14 when the case was filed, and he's currently 18. He attends St. Mary's College in Moraga. He is a passionate fly fisherman, and he's fished with his dad since he was 4 years old. The warmer water temperature, the lower oxygen levels, and the declining in-stream flows due to climate disruption are harming Montana's rivers and fish. And so he's had to cancel a lot of fishing trips, not only because of the weather, the temperatures, but also because of wildfires. Climate change is affecting the outdoor activities that are crucial for his emotional health and foundational to his family. So without further ado, I'd like to introduce our main speaker tonight, Phil Gregory.
So let's give a big round of applause for Terry for her. Can you all hear me?
Yes.
Okay, if you can't hear me at any point, throw a rotten tomato, something along those lines. Okay, so the cases I'm going to be talking about have been brought by a nonprofit called Our Children's Trust, which Terry alluded to. And we started in 2010 based in Eugene, Oregon. And essentially what we're trying to do is elevate the voices of diverse youth and future generations, because we all know the climate crisis, or as Kurt Vonnegut put it, when the excrement hits the air conditioning, that's going to occur primarily for youth and future generations. And what we advocate for is science-based, and this is crucial, science-based, not politics, not economics, but science-based and legally enforceable systemic remedies against governments in court throughout the world. So let me give you examples of systemic litigation. The school desegregation cases culminating in Brown versus Board of Education, Pacific Northwest Treaty rights, the public housing desegregation in Chicago, and the California prison litigation. Our Children's Trust right now has cases either in development or on file throughout the United States. That includes Virginia, Utah, and Hawaii. And we also have cases that we're involved in throughout the world. So Canada, for example, in India, in Pakistan, so throughout the world. And at the end, I'm going to show you where our Children's Trust website is. So if you want to know any specifics about any of these cases, they're all outlined there. Terry alluded to the case Juliana versus United States, and that case is brought by youth against, and the youth are pictured here, against the federal government. And essentially that case was brought during the Obama administration in August 2015 because of the federal government's affirmative acts. And I just want to stop right here. We don't bring cases because the government isn't doing something that it should be doing. We bring case, or what's called inaction. We bring cases because the government is affirmatively putting its foot on the fossil fuel accelerator and causing the climate crisis. And so in Juliana, it's federal constitutional due process rights for affirmative ongoing conduct persisting over decades and creating, controlling, and perpetuating a national fossil fuel-based energy system despite long-standing knowledge of the resulting destruction to our nation and profound harm to the plaintiffs. That case is up in Eugene, Oregon. It's in federal court before Judge Ann Aiken, who the day after the election in November 2016 denied the federal government's motion to dismiss, stating that she had no doubt that the right to a climate system capable of sustaining human life is fundamental to a free and ordered society. And Judge Aiken's ruling marked the first time that a court had declared a constitutionally protected climate-specific right. Essentially, again, pointing out that it's government action that is affirmatively and substantially damaging the climate system. That case went up on appeal. We had oral argument in 2019, and in January 17, 2020, the Ninth Circuit, because it's federal court, issued a decision that had several parts. I'm not going to go into them all, but the two key parts we want to talk about is that they found there was a substantial evidentiary record that the federal government has long promoted fossil fuel use despite knowing that it can cause catastrophic climate change, and that failure to change existing policy may hasten an environmental apocalypse. But the court said it's beyond the power of Article 3. Article 3 in the federal Constitution sets up the judiciary. So it's beyond the power of the judiciary to order the plaintiff's requested remedial plan. In essence, what we wanted the federal government to do is, look, you're causing all these problems. Those problems are injuring these plaintiffs and the youth in America, and so the court should do something about it, because we all know the executive and Congress are going to do bupkis about it. But the court said, no, you know what? We don't have we don't have the ability, is the word, what they said. But they just balked at this. The dissent, a judge from Southern California, said the relief that we were requesting, much like what I earlier said, the desegregation orders and statewide prison injunctions, would vindicate the plaintiff's constitutional right without exceeding the judiciary's province. So we went back to Judge Aiken, we amended our complaint, and she granted our motion to amend the complaint. So and that was in May of this year. And so now we're waiting to get a prompt trial date up in Eugene. We don't yet have a trial date, but we're hoping to get one in the first part of 2024. And if you want to know about this case, those of you who have Netflix, there's a movie, a wonderful documentary called Youth v. Gov. It won all sorts of awards. It was on Jane Fonda's first film that she put on her Friday night program during the pandemic, etc. And it's a wonderful movie all about Juliana, and I highly commend you to watch this. It particularly goes into the plaintiffs and their stories. But let's turn now to Held versus State of Montana. And I want to just point out that this was filed March 13, 2020. March 13 is the day the pandemic orders came down. So it was literally one of the last cases filed in the state of Montana. And essentially, it's youth from around Montana. So Lander and Badge are way up here, all the way over to Ricky Held, who's over in eastern Montana, in Broadus, Montana. But it's youth from around the state. And I want to give you a little bit of background on why we brought this case in Montana. Our first witness at trial, our trial started June 12 of this year in state court in Helena, Montana, before Judge Kathy Seeley, a state trial judge. And our first witness was May Nan Ellingson. And May Nan, the interesting thing about her is back when Montana had its constitutional convention in 1972, she was the youngest delegate to that constitutional convention. She was 24 years old. And May Nan was then living in Missoula, and Missoula at the time, with smokestacks, all sorts of air pollution and the like, was really contaminating Missoula. So May Nan was instrumental in getting inserted into the Montana Constitution a section that says the state and each person shall maintain and improve a clean and healthful environment in Montana for present and future generations. It's also part of what are called the inalienable rights in Montana. And these rights include the right to a clean and healthful environment. So Montana's Constitution, I'm going to call it very enlightened, has various rights for the citizens of Montana. A right to a clean and healthful environment, a right to individual dignity and equal protection of the laws, right to safety, health, life, liberty, and property, and that those under age 18 enjoy all the same fundamental rights. So you don't have to be a geezer to get fundamental rights. It applies to everybody who's in Montana. Why not? So the clean and healthful environment finding that we're going to talk a little bit more about later was essentially that the fundamental right under the Montana Constitution, Judge Seeley found, was being violated by the state's ongoing promotion of fossil fuels while ignoring the climate impacts. So what led her to this finding? Well, Nationally, there's the National Environmental Protection Act, that's called NEPA. Montana, in its wisdom, has a Montana similar provision called MEPA. And essentially it's what government agencies consider in whether or not to issue a permit or enter into a lease, things along those lines. In 2011, the Montana legislature, in its, I'm going to call it as a result of, passed a provision that says that when the state reviews things like permits, they can't review actual or potential impacts beyond Montana's borders, okay? So we said, well, that means they can't review fossil fuel emissions or they can't review the impacts to the climate. And amazingly, while we were in trial, the getting ready to go to trial in May of 2023, the legislature made it explicit. It said that essentially when agencies do environmental reviews, they cannot include a review of greenhouse gas emissions or the corresponding impacts to the climate, whether in the state or outside the state. So why is that important in Montana? Well, there are fossil fuel projects all over the state. Rosebud coal mine, for example. They didn't consider emissions, either in-state or as a result of the mined coal, or any impacts. And the Rosebud, even when Rosebud, a very large mine, and you're going to see a little bit more about this in a minute, even when it expanded, and that resulted in Rosebud, this expansion, in 70.8 million tons of coal. But fossil fuel emissions, climate impacts, they weren't an issue considered by the government. So all over Montana, you have coal mines, you got pipelines, you got oil and gas extraction, you got coal and gas power plants. And so our position is that the state has an energy policy, and that's to promote fossil fuels, not just consumption in Montana, but extraction and exporting or transportation through Montana. And the state is turning a blind eye to the effects of what all these, what the state fossil fuel energy system is causing. So even though we sued over the climate crisis and said fossil fuels are damaging and everything along those lines, the state, when it responded to a complaint, when you do, I'm going to turn you all into lawyers by the end of the night, so be careful, you might have to get vaccinated. But when you file a complaint, the other side files a document called an answer. And essentially they admit or deny. Well, the state denied that climate change is caused by human activity or fossil fuels. It said that they denied anything regarding climate impacts in Montana, climate impacts to the plaintiffs. They denied all allegations regarding the availability of renewable energy sources as an alternative to fossil fuels. Now we're going to hear from two plaintiffs, so I'm not going to go into their impacts, but essentially we started the trial on June 12th. Like I said earlier, it's a court trial in front of Judge Kathy Seeley. We started with Maynann Ellingson, and then we, in essence, went with an adult witness and a youth plaintiff witness. An adult witness, a youth plaintiff witness. And so the impact to the plaintiffs and their testimony, I've been practicing for over 40 years, and I've never heard anything like the testimony of these plaintiffs. They were remarkable. I don't know what you were doing when you were 14 or 17. I wasn't suing a government, okay? I wasn't being deposed by the state attorney general's office. I'm not going to tell you whether or not I was sitting in a courtroom at some point in my life, but at age 14, 17, they got up on the witness stand, and I want to tell you this, the courtroom we were in, it's in Helena, and it was the first, the court building, the courthouse, was the first set of courts for Montana. And the jail was across the street, and this courtroom was just like in the movie, if you've seen it with Gregory Peck, To Kill a Mockingbird. It had the balcony, had everything along those lines. And the courtroom was packed. I said there was a jail across the street. That had been turned into a theater. And the theater, we had live stream in the theater, and that theater sat 200 people, and that was packed. In fact, it was more packed because the seats in the theater were more comfortable than the seats in the courtroom. But the plaintiffs all got up there and told their stories. And they were remarkable. They were really genuinely remarkable. And Judge Seeley found regarding each of the plaintiffs that they had proven that as children and youth, they're disproportionately harmed by fossil fuel pollution and climate impacts. And that if there was an order issued by the court, that would provide meaningful redress to these injuries, because the amount of additional greenhouse gas emissions emitted into the climate system today and in the coming decades will impact the long-term severity of the heating and the severity of plaintiff's injuries. She, among other findings, she found that, and I should just, we're going to allude to this in a bit, but she had a 103-page order of finding at trial. It's a remarkable document. I'm going to give you the way to get to the Children's Trust website. You can read it there, but each of the plaintiff's harms is detailed by Judge Seeley in her findings of fact. We also had experts from around the country, but primarily Montana-based experts. Steve Running, I don't know if you remember when all the hoopla of Al Gore winning the Nobel Peace Prize. Well, he won half of the Nobel Peace Prize. The other half went to authors of reports called the IPCC reports. And the lead authors were also recognized as part of the Nobel Peace Prize. Steve Running from the University of Montana was one of those. And Steve testified about the Earth's energy imbalance and climate trends. And in essence, what we did was Steve was our first expert witness, and he set out what the climate crisis is all about. And then Dr. Kathy Whitlock, who's at Montana State University, she really honed in on what is going on from a climate change perspective in Montana. And both of their testimonies were remarkable. Steve talked about the Keeling curve, and I don't know if any of you have heard of the Keeling curve, but essentially it tracks parts per million. So it's essentially based on an observatory in Mauna Loa, and it started in the late 1950s and kept track. Well, what are we doing to put stuff from fossil fuel emissions, primarily CO2, into the atmosphere? So back when Dr. Keeling started this work, we were at 316. Dr. Jim Hansen, who's another one of our experts in the Juliana case, and Jim is the scientist who testified at the hearings in 1988, where he first revealed what the government scientists were saying about global warming. He came up that for us to be stable, for our climate to be stable, we have to be at 350 parts per million or less. We're now at 422 plus. But the interesting thing I want to point out to you, and this is part of Steve Running's testimony, is, yeah, we got up here quickly, but you know what? If we start acting now at the appropriate scale, we can get down